this amount of money. So I verbally stated the صيغة, or I expressed my intention to sell. I expressed it verbally. Okay, this is called الصيغة القولية because it's verbal communication between the two. Or it could be the so-called الصيغة العملية, which is a passive way without talking. Okay, like if I place, sometimes when you're driving by some homes, you find a basket full of orange and they put a sign that says 2 for $1, and then they place a box where you put the money. Okay, now you grab 2 and you put $1. This is a contract. Okay, but here the صيغة, the format is not verbal. There is no talk. Or when you go to the store, okay, you purchase your fruits, and for example, for oranges or for apples, 1 pound for $1.49. Okay, so you pick your oranges, you give it to the cashier, he will weigh it, and then you look and you see the price, you hand him the money. There is no talking. Okay, both types of صيغة and format is acceptable. So the format does not have to be verbal. You don't have to speak. Your format, your صيغة, it could be صيغة عملية, that's like, just hand him the object and he hand me the money. And here we have some examples. Inshallah, when you go and read on the handout, inshallah, go through those examples. The different types of the صيغة, like a vending machine. Okay, then you have everything inside and you know the price. You have to drop your coins and you receive your merchandise. There is no talking.
Not always.
Huh? Most of the time. طيب. طيب. Now, as I said, there are 2 types of صيغة. It could be either verbal, or it could be just, without saying anything. Okay, now what are the conditions for the validity of the صيغة, or the validity of this essential component of this rukun? Okay, but the first condition, that the offer and the acceptance must be obvious in indicating the absolute will of the contracting parties to enter into the contract. And this is the main purpose of a صيغة. Okay, and subhanallah, in Islam we have this many conditions, to make sure or to eliminate any possibility of disputes in the future. Okay, if all those conditions are fulfilled, believe me, there will be no disputes or any disagreement among the 2 parties in the future if they follow those conditions and regulations. Okay, so the first condition, that the صيغة must be very clear in indicating our willingness to enter that contract. So I will say to you, بعتك هذه السيارة $1,000. Okay, I am selling this car to you for $1,000. And then you must reply in a way to indicate your acceptance. Okay, that I accepted purchasing this car for $1,000. Very clear. It must be very clear to indicate our will to get into the contract. And this is an obvious condition. طيب, the proper matching between the offer and the contract, this is also common sense. If I said to you, I am selling this car to you for $1,000, my Honda 2010 for $10,000. And he said, I accepted purchasing your Honda 2010 for $8,000. This is not a concluded contract. Why? Because there is no matching between the offer and the acceptance. Unless if I get back and I said, okay, I will sell this car to you for $8,000. This is a common sense. Okay, if I said I'm selling my computer to you for $500, I said, okay, I'm going to purchase your smartphone for $500. It's not acceptable because there is no matching between the offer and the acceptance. The proper matching, even in a marriage contract, and from time to time I make analogy to marriage contract. In marriage contract, if he says to him, I will marry my daughter Fatima to you, and he says, I accepted marrying your daughter Zainab, it's invalid. because there is no proper matching between the two.
both the offer and acceptance are to be jointly
connected
in one single session without any gap in time or place. Now we are sitting here to conduct a contract. Okay, I give you the offer. You must write away respond to my offer by your acceptance. Okay. Now, if I gave you the offer, and then your telephone rang, and you get for 15 minutes talking to your friend, and then you said to me, accepted that. This is invalid. Why? Because there is a gap between the offer and the acceptance. So both offer and acceptance must be jointly connected without any gap, in time or in place. Okay. Now, if I said to you, I will sell this object to you for $100, then you pick the telephone, okay, and you talk to your friend, okay, you are consulting him about this deal, and you talk to him for half an hour. This is considered to be separation, because your conversation with your friend has to do with this very contract beforehand. So this is considered to be separation. But if you are talking about something which is like you are discussing with him, about yesterday football game, okay, this is considered to be separation. This is improper. So both of them must be jointly connected in one session without having, separation or any gap, excuse me, in time or in place. In place, like what? Okay, like I gave the offer, then he went outside and then come back. The separation on time and also in place, because we have to be staying in the same place. Okay, and inshallah later on I'm going to talk about same place if you are purchasing through a phone or from the internet. Okay, how the scholars defined. This is called the meeting place, or the place at which we conducted the contract. Yes?
So, if someone makes me an offer, if someone makes me an offer and I say, I need to think about it.
Khalas, there is no contract.
There's no contract.
Yeah,
right?
you can call it, I promise to purchase that. Okay? It's not a contract.
Right.
Yeah. A contract is not concluded until and unless all the essential components and all the conditions are fulfilled. Otherwise, the contract is not there yet. Yes.
So it's not proper, but it doesn't mean it's not valid. Is that correct?
Yes.
Okay, but it still can be valid. So if just to follow up on what Omar said, that if you say, okay, let me think about it, and I'll give you a call.
When you give him the call, he has to. But here, because of the separation of time, he need to re-offer it again. Okay, then he must accept it at that time. Now, at that time, the contract is done. Like after a day or 2 or 3 or a month, that okay, I made up my mind, I want to purchase it. Okay, then he has to offer you, yes, I will sell it to you for $10,000. He said, I accepted that. The contract is a done deal. It's concluded now.
But they don't have to be in the same place.
This is different. What's meant by the same place? Is nowadays we have a broader definition to that, because you might have a seller here and a buyer in Cairo, for example. Okay, we will talk about that. Even in marriage contract now, the wali might be back home in Pakistan, and the husband is here. So inshallah, I'm going later on to talk about what do you mean by the meeting place. Now,
so just to follow on what they said, if somebody offers something, like somebody wants to sell me something, and I said I need to think about it, and then I went and thought about it, and then called him back and I said, okay, I agree to buy your car for $10,000. Is it okay for him to say okay, or does he have to verbally say that and offer it to you for $10,000 and I say I'll accept it for $10,000?
It's preferred to have the offer from him. Being clear at the beginning will eliminate any possibility of disputes and disagreement in the future. Okay, but if he says okay, that's acceptable. But it would be better, to give the offer again. I'm selling this car to you for $8,000, and then he would accept it that.
So are you saying that sales initiated by a buyer are not acceptable?
Exactly.
Like if I saw his car and I like his car and I say, well, I'll buy your car for 10,000.
And he said accepted, is acceptable. But
he did not want to sell the car to begin with, but I offered him something and he liked it.
And he says, okay, I accept it. Khalas. This is just like in a marriage contract. In general, a marriage contract is preferred that the offer must be initiated first from the wife's side. So the father would say, I marry my daughter to you according to the book of Allah, the Sunnah of Rasulullah. Then he would say yes. But what if he asked him to marry his daughter to him? And the father said, I accepted that.
Which is the most common thing that happens.
But for the majority of the scholars, they go with the offer first done and placed by the father or the wali, for example. And then, but in fact, if it does the other way around, it will be acceptable too. Okay, we need to have offer and acceptance in a very clear way. The more clear the way, this will be more preferred. طيب, this is the second condition for the sigha, that both acceptance and offer and acceptance must be jointly connected in one session. Instead of using place, we use session, in one session, without any separation or any gap in time or in place. طيب. Yeah, go ahead.
What brother was saying, like as far as I know, the Prophet
sallallahu alaihi wasallam,
all the proposals, most of the proposals, they were originated from the men's side, and then the father of the girl said, yes, I accept that. As far as I know, that was the case. Only exception of few cases, even in Rasulullah case before Islam, Khadija offered, but then to keep the respect and the tradition, Rasulullah sent his uncle to ask for her hand. So that was like in Medina, most of the time it was the men's side that they would go and they would ask for the hand of the daughter.
Okay. طيب, what he's saying that most of the marriages took place at the time of the Prophet ﷺ. We have the offer is from the man's side, not from and I don't agree with that. Okay, because in many instances, like for example, when the Prophet ﷺ married Zainab, Allah subhanahu wa ta'ala is the one who married her to him, and Allah says زوجناكها. Okay, that we married her to you. Okay, but anyhow, the purpose of acceptance of the sigha is to make it clearly that both parties express their intention to enter the contract in very clear manner. Okay, the third, here we have a point related to the session. This is very important thing. Okay, because as long as the two contracting parties are available in the same session, then they have the right to revoke that contract after the conclusion of the contract. Okay? Like for example, if I sold a property to you for such and such amount of money, and you said I accepted that, this is called a concluded contract, right? The contract is done. But as long as me and you are available in the same session, okay, even for hours, then each one of us has the right to revoke that contract. He can change his mind anytime. يقول النبي صلى الله عليه وسلم البيعان بالخيار ما لم يتفرقا. The two contracting parties, the seller and the buyer, they have the option to revoke the contract, unless if they are separated. Okay? So this is why we keep mentioning the same session. Okay? So each one of the two parties has the right to revoke the contract. Example, if you are traveling with a brother, you're on aboard the plane, and the trip is like 13 hours. Okay? While you're sitting, he says, my Honda 2010, I want to sell it to you for such and such amount. And then you said I accepted that. Now this is a concluded contract. Okay, now you are going to be for 13 hours in the same place. So each one of you has the right to revoke that contract. But if you are interested in that deal and you don't want to miss it, you can lay a condition. Say, okay, you purchase your Honda, providing that you do not have the option to revoke the contract. Okay? You can stipulate many conditions at the time of the contract. This will be a different section. But to show you the importance of the session, Because as long as you are both of you in that plane for the 13 hours, any one of you can revoke that contract. If you did not stipulate a condition, to ban him from revoking it. Okay? Yes.
Now, is this rule also valid in the marriage contract?
No. In marriage contract, this option is not there. Once the acceptance and offer are done, that's it. This is one of the differences between a marriage contract and a business contract. A business contract, as long as the two parties are available in the same session, each one of them has the right to revoke the contract. Okay? But if one of them departed and then come back, then that option is over. That option is over. Okay? Inshallah.
Yeah, but just to make sure I understand, what happens, sometimes parents, they agree among each other with the approval of their kids. Okay, we're going to get married and stuff. But later on, maybe 6 months later, because everything is verbal. There is no nikah, no written contract. But maybe 6 months later, the boy says, I'm changing my mind. I don't want to marry her anymore. So what's the rule about that?
One of the, we said contracts are binding. It's not, up to, once we conclude the contract, then the options to revoke the contract, I'm not saying there is no option, but it will become very limited. Okay? Now in marriage contract, if both of them, the man and the woman, both of them must, enter in that contract with their mutual consent without being forced to enter it. If they accepted that and the contract is done, then that's it. They cannot revoke it. But for him, if you want to divorce her, it's a different thing. There is ways to end or terminate that marriage contract.
No, but I think the contract here I'm referring to is not the nikah. The thing has done yet. It's like engagement.
Oh, engagement is different.
Engagement contract.
No. Yeah, engagement is a promise. But a contract, which is the nikah.
Yeah, that's it.
Oh yeah, the engagement is different. طيب. The third condition for the format, that the format must be unconditional. Unless the condition is a part of the transaction. Okay? يعني it must not be conditional. You cannot say, can you say to a purchaser, I will sell this object to you, if it's a car, for example, providing that you will not let Muhammad to drive it. Is this a valid condition? No. Can you stipulate such a condition? No. Or can you sell a house, providing that this house must not be inhabited by Ali, because you don't like Ali. You are the owner, but he says, I'm going to sell this house to you, providing that you will not let Ali to rent that house. Because a sale contract, yes, go ahead. A sale contract is to transfer the ownership from A to B, from party A to party B. Okay, once it's transferred, khalas, it's not your property anymore. So this condition is invalid. A valid condition if it serves the purpose of the contract. Like, okay, I'm going to purchase your car, providing that you provide service for this car for 2 years. This is a valid condition, and it could be stipulated, and the contract is acceptable. It's a condition, but because it has to do with the very contract itself. Okay, like I'm purchasing the car, providing that you provide service for 2 years, or for 50,000 miles, or 100,000 miles. Okay, this is a valid condition. But when we say it must be unconditional, you cannot put any condition that goes against the purpose of the contract. Because the purpose of a sale contract is to transfer the ownership completely from the seller to the buyer. Okay, so the third condition, that the sigha must not be conditional. Here is the example that I have mentioned. The example for a valid contract is like, stipulating, having service for the car for a period of time. The fourth condition is the immediacy of the offer and acceptance. You cannot say, I will sell this car to you tomorrow for $10,000. If you said accepted, this is not a valid contract. Okay? If you want to sell it tomorrow, let's do the contract tomorrow. Okay? And this is also a common sense. Okay? You cannot say, I will marry my daughter to you next month. No. So wait until next month and then do the nikah. The same thing is for the contract, the business contract. Yes, go ahead. Yes.
So, does that? So the question with that is, let's say for example, right now, I'm a reseller of some products, right? And I don't own it. I don't have it yet. So I wait for the customer to say, I want to buy it.
Okay.
They give me a legal a contract that says I will buy it at this price, right? Then I go and purchase that product from the manufacturer, and then I ship it to the customer. Is this a compliant transaction?
Yeah, this is a contract. This is a promise, because he promised you upon delivery of the car he's going to purchase the car. Is this a contract? Is he buying it? No. But maybe if it resulted in some harm to you, maybe penalties or fees or things could be applied, or he must pay, for example, some type of compensation to you, okay? Because you brought the car all the way from Japan, it costs you money, because he promised to do that. This is a type of a promise. We said, when we said the difference between a promise and a contract, that the promise is not binding. But there are some exceptions, we said. If a promise resulted in harming the other party, then it becomes binding. Okay, so he does not have to purchase it, but you can sue him and he can pay for or compensate you for all the losses that you suffer because of his promise. But it's not a contract, because a contract has the immediacy of the contract must be there, that I'm selling this car to you for such and such amount of money, and he would say accept it. But it's not. You cannot say in a contract, I will sell this car to you tomorrow. There is a difference between the immediacy of the contract and later delivery of the object. Brother, for example, I will ask you this question. If I said I'm going to sell my car to you for $5,000, okay, but I will deliver it next month, is this a violation of this? No, because I am selling the car to you now, but the delivery in a later date. This is acceptable. But you cannot say to him, I am selling this car to you a month from now or next month. And he said, I accepted that. This is not a contract. This is a promise. Okay?
So
yeah.
just as a follow-up. So is that mean I can sell somebody which I don't even have it, I don't own it?
This is a huge area of disagreement among the scholars.
That was basically his question, I think. Okay. Yeah, he doesn't own that thing yet. He doesn't have it. So, is it allowed to sell something which I don't even own it?
Right. This is as I said, this is an area of disagreement among the scholars. For the majority of previous scholars, you cannot sell anything that you don't own or not in existence, with some exceptions. According to Shaykh al-Islam ibn Taymiyyah, he said there is no single verse in the Quran or the Sunnah that prohibits that. What's prohibited is to get into contract with uncertainty. If you are certain enough or most likely that you will be able to deliver, then you can get into this contract. And the majority of contemporary scholars and bankers, Islamic bankers, they adopted that opinion. Okay? But for the four Imams and the early scholars, they do not accept that. Okay? But inshallah, this is an area, I have a very good article. It is in fact like thesis, master's thesis for master in one of the Islamic universities about this issue. A whole thesis about this issue. Can you sell things that is not in existence? Because even the early scholars, they have exceptions. There is the so-called Bay'u Salam. Okay, Bay'u Salam, look, is to pay now, not to deliver now, no. Deferred sale is to pay me now, deliver now and pay me later. Okay, so this is called deferred sale. Okay, Bay'u Salam, which is forward sale. Okay, in the deferred sale, you receive the merchandise, but you pay later. Here is the opposite. Okay, I receive the price, but I will deliver. Like for example, a tailor. If you go to a tailor, even in the old time, you pay him the money. The tailor does not have the fabric. He will get the money and then purchase the fabric, and so he is selling something which is not in existence now. Okay, those are some exceptions, but for the majority of the scholars, anything which is not in existence, you cannot sell it.
So
it has to be in existence at the time of the contract. It does not have to be here. It could be in India, but it must be in existence now. This car is existing now in India. You deliver it in a month, in a year, no problem. Okay, but selling a car which is not manufactured yet, okay, or selling a product that you don't have an idea where you're going to get from, according to those scholars, is not acceptable. According to Ibn Taymiyyah and other scholars, especially contemporary scholars, as long as you are able to deliver it, then you can sell it. Okay? Further.
I think you just clarified it. Because there's a difference between in existence and in your possessions, right? So it doesn't, as long in existence, it's not being created.
Yes.
But if it's not in my possession and I still can deliver it, that is valid.
Yes.
Okay, got it.
No, accord is still.
Only Imam, this is only how to find out. This is the only, as I understood you right,
okay,
unless I'm making a mistake here. So this is the only opinion of Imam Ibn Taymiyyah.
No. I said, for the majority of the schools, known schools, they against that. Okay.
Yeah, that's what
they have some differences, but in general they agreed. Anything which is not in existence or not in your possession too, you cannot sell it. Okay. This is one thing. But when we say the four imams, they are more than, in Islam we have more than the four imams.
Right.
Okay.
Right.
Okay. Yeah, and there are other scholars who talked about this issue. Okay, but not the four imams, the four non-imams. This is what I meant by that point.
There are some exceptions, you said.
Right. Yes. Yeah. And anyhow, it says even according to the four imams, there are some exceptions, because Bay'u Salam is selling something which is not in existence, but it is deliverable. Okay. Like for example, a builder. You can go to a builder and ask him to build a house with this specification. It's not in existence yet. You tell, okay, I will do that for $400,000. Okay, this is called Bay'u Salam or al-Istisna'. Okay, it was the contract of manufacturer. You pay him the $400,000, then he will deliver it in 6 months or a year. It's not in existence now. It's an exception, even if this accepted by early scholars. Okay, and this is used by Shaykh al-Islam Ibn Taymiyyah. He says, okay, you accepted this. Also for farmers, they need money, but they expect, the produce in 5 or 6 months. They can sell that produce or part of that produce now, even it's not in existence. So Shaykh al-Islam Ibn Taymiyyah and others, they use, those exceptions. They said, so this means that, and providing that there is nothing in the Sharia that says.
Yeah, but if I'm selling my crop, I'm not certain if I'm going to have that crop healthy and enough of it.
Okay.
There's a chance there might be no rain or no water.
Exactly.
I don't have anything. And if I've sold you 5 tons of wheat already, it's uncertain.
That's correct.
So
yeah. At the end, I'm talking about the validity of the contract. Is this contract considered to be valid or not? Now, if you fail to deliver, even if the car is in existence now, okay, and we did the contract is concluded and correct. If you fail to deliver, then I have the option
to take my money back. Yeah. I'm not talking about the contract itself. Can a Muslim get into such a contract that involves the sale of non-existing item?
So hang on. I have a okay. So the one of the key parts of this, all right, and this comes back to the initial question I asked. So let's just say now you give me a contract and I need to build something for you, right? But I only get the money from you once I'm finished with it and I deliver it.
In this case here, عقد الاستثناء, you pay first.
Right. No, but I'm saying in this particular case, the kind of transactions I get involved in is I only get paid once I deliver. I don't have ownership of it, but once they say I get this, then I get everything. I sell it to them. They get it. It is exactly as what they expect.
Yeah, for example, the client will come to you and he says, "Okay, I need you to build a house with such and such a specification," right?
Right.
Then you sign a contract with him.
Yes.
That this will cost you $400,000, for example.
Upon delivery. Right.
Upon delivery.
Right.
عقد الاستثناء, which is the contract of manufacturer, that the money, or at least part of it, has to be paid in advance. Okay? For example, you can ask for 10% down, and the rest being paid, throughout this period or upon delivery. But part of the money has to be paid, at the time of the contract.
So in this particular case, though, that I'm talking about, what I do is I do it with the government, right? So the government only pays after you give them. They don't pay in advance. So let's say they want to buy a computer. Make it simple, right?
Okay.
They want to buy this computer with this specifications. I don't have it right now.
Okay.
Because it's custom. So I go order it, right? They make it. They ship it to the customer. I pay, right? Or actually, most of the time I wait till the government pays. So I have not paid yet. So he delivered it. He says, you have 30 days to pay me, right? I deliver it to the government. The government says, yep, this is exactly what we promised. This is the contract. They give you a contract.
Okay.
It says you deliver this to me, and I'll pay this for it.
Okay.
Then they say, yes, this is exactly what you said. We're going to pay you this price. They pay me. I receive the money after they receive the product, and then I pay the other company that made the product.
Okay, but you will have that first. You will have it in your possession first, right?
Well, I guess the definition of possession is that that contract I have.
You finish with them.
They're building it for me.
But you paid them, and everything is now.
No, not yet.
None.
They give you net 30 terms. So there's no. So basically, what happens is, as an example, this is like medical research. This is all about. I do medical research, right? So they say, hey, listen, we're going to deliver this piece of equipment that does this type of research.
Okay.
Right? DNA analysis, whatever. Right? They make it. They ship it to the government. Right? Directly. But the contract is between me and this company.
Okay.
They do not have a contract with the government.
Okay.
Right? I give them a purchase order, which is a contract.
Okay.
They accept it.
Okay.
They deliver it. I tell them where to deliver it to. They deliver it to that place.
But if you break this down, it is a complex contract. It's not one contract. Yes.
Right.
Yes. There's a contract between you and the manufacturer.
Correct.
Now, tell me of the nature of that contract. Do you pay them?
Yeah, they give me 30 days to pay them.
خلاص. This means that 30 days we can consider as payment in advance, because sometimes in advance doesn't need to be in a spot, but before they start manufacturing or before finishing manufacturing or building that thing. Okay, so this contract is correct between you and them.
Okay.
Okay. Now the second contract, which is between you and the government, right?
Mm-hmm.
Now you own it,
mm-hmm.
because you paid for it and it's going to be manufactured and you own it by that contract.
No, he hasn't paid yet.
He hasn't paid yet.
No, he's not paid. No, he's not get paid by the government.
No, he hasn't paid.
I haven't paid the manufacturer yet.
But you have.
So what he's doing, I'm sorry, because I dealt with this and I'm still confused.
Okay.
Because what he's doing, in simple words, he's not doing. There's no money exchange between him and the manufacturer. Nothing. What he's doing, he's making an order, make this chair for me for $5. Before he makes an order, he has a buyer that he'll buy that chair for $6.
Yeah, but the buyer give him the money or you
no money exchange.
طيب, within just 30 days, okay, who is going to pay the manufacturer? You or the government? I pay the manufacturer. ما خلاص, what matter, you know, what matters? He will pay the manufacturer. Now he is the owner of that product.
No, but yeah, Sheikh, he hasn't paid anything yet.
Within 30 days.
After he gets paid.
No.
After he sold the chair, no?
After 30 days after they deliver, he gets the what. Usually, this is exactly what happens.
Yeah.
Right. This is exactly what happens. Right. Because this. I think that a lot of people do reselling, right? So this is not, and they get terms, even in Islamic bookstores and everything. It's very common. What happens is that I get a contract. It says I want to buy this for this price. I go to this place that has it. I say I want this.
Okay.
For this price. Right? They make it for me, and I have them ship it over there. I don't pay for it yet, right? Because I only pay for it once it is what they said it was supposed to be.
Okay.
Right? Make sure that it is, right? Once it's received, they say this is exactly what we want. They're going to pay me. They pay me usually within 2 weeks, 3 weeks, right? I take that money the next day, and I pay the company that made it.
So he keeps his share of the profit.
Right.
And pays the manufacturer.
Correct.
Is that correct?
والله يا أخي شوف, I need to, يعني, this is very complex issue. Okay, because now we want to know, to figure out, you know, what type of transaction is done here. Are you working like as an agent who get commission because you don't, you know, you are not a seller because you do not buy anything.
Right.
Okay.
Right.
What happens as if you are just, you know, just getting a commission. Okay, they will give you, say, the government will give you $1,000, and you need to pay those $800. So you get this $200. It could be, we can say this is a commission contract. You're just getting a commission.
Right.
Okay, but I need to think about this, inshallah.
Okay, inshallah.
Yeah. No.
Are we going overboard with all these questions?
About
Yeah, I think we can get to the specific transaction.
Okay. So you are saying, and I said, you know, any question that's related to the point we are discussing, we can answer it. But if it is related to things we have not discussed yet, it's preferred to be, inshallah, delayed later on. No.
Yeah, two things. What the brother was saying is becoming very common. It's a type of virtual organization where the person that's initiating, he doesn't have these things, but he involves another party and then he sells to another party, and most of the time the things never come into his position. So this is type of virtual organization.
Commission.
Yeah. So actually I have a question about another thing. You were talking about the conditions that the contract or the seeker has to be unconditional. But one of the things is that we see in the house transaction or other transaction is relating to the quality or the condition of the merchandise. And that's like, or the fair price of that based on that condition. Sometimes you are told one thing, but you found that the quality or the conditions were not matching there. So where do you put this? Are you putting that in the matching, or where do you put that?
No, inshallah, there is a part which called the options to revoke a contract. Okay, especially if you purchase something over the internet. Okay, but just by seeing a photo, or in accordance to certain specification. Like, for example, I want to purchase, or I want you to build this house, or to bring this merchandise to me with the following specifications. It must be this model, which has air conditioning, power windows, everything of that. Upon delivery, if anything does not match the specification, then you have the right either to revoke the contract or ask for reduction in the price. This is called khiyarul aib. If there is any defect, a defect, it means that anything which is not in accordance to what has been, you know, shown to you, then you have the right either to revoke, or you can ask for compensation or reduction of the price. طيب. Now
Assalamu alaikum.
Wa alaikum
Sorry,
salam.
I have a question. Is it permissible to put a stipulation for resale, like I will sell this to you, but only you can use it, it's not to be resold?
No, you cannot do that because we said one of the conditions of the sigha, of the format of the contract, of the wording of the contract, it must be unconditional. Okay, any condition that restrict my ownership, because a sale contract is to transfer the ownership from the seller to the buyer, from the seller to the purchaser. Okay, complete owner, it must be completely transferred to the other party. So he cannot stipulate this condition. Okay, he cannot stipulate such a condition. Right. This is what's meant by the sigha must be unconditional. Okay, but if the condition serves the purpose of the contract, like asking for service or maintenance or things like that, that would be acceptable. Now, we talked about the conditions for the two parties, the conditions for the sigha. Now, the third pillar or rukun of contract of sale is the subject matter, the price and the merchandise. Al-mabi', the merchandise, and al-thaman, which is the price. For both of those, there are certain conditions. The first condition concerning the merchandise, it must be lawful, something which is permissible to trade. This is obvious, because now we're talking about business transaction in Islam. For example, selling liquors is unacceptable. Okay, so anything that's prohibited for us to use or to consume is prohibited to us, for us to sell or to trade or to rent and things like that. Musical instruments cannot be a subject matter of a contract. Okay, liquor, gambling instrument, anything that is used, in or it is haram for us to consume or to trade or to use, cannot be the subject matter of that. It cannot be a merchandise and cannot be a price. Okay, this is a very obvious condition. It must carry a legal benefit to the buyer, usually in the form of property or service received. Then it has to be something that has a value, because we said it won't fit with the definition of al-mal, if it does not have a value. طيب. It must be legally owned, okay, or authorized by the parties. Now the two parties, the object that is transferred, the ownership of that object that transferred from A to B, it must be owned by the seller, or you must be the authorized agent, the authorized representative of that seller. I own the car, but Kamal is my representative. I delegated Kamal to do the contract on my behalf. Okay, this is also an obvious thing that. Okay, I don't know what happens here. I did not hit anything. Okay, but now I'm trying.
The words are so big, brother,
But let's use the mouse. Okay. Yeah, this is called tawkil. No, okay. Okay. This is called wakala. Representation is tawkil. You can delegate anyone to conduct. Either you can give him a limited authorization or unlimited. For example, if you are very rich, you have properties, you can assign someone to do contracts on your behalf in everything. Give him unlimited authorization, or limited, only just the properties, only the cars, only the houses. Okay, so you should either be the owner or the representative of the owner, and this is also a common sense. It must be in existence at the time of the sale, with some exceptions. Okay, so this is by the vast majority of the scholars, with the exception of what Shaykh al-Islam Ibn Taymiyyah and other scholars said, that we should just refine this, instead of say it is in existence, that most likely it would be in existence and it could be delivered. Okay, and he says there is no specific evidence that suggests that it has to be in existence, because what matters, that is it deliverable or not. Okay, because sometimes it might be in existence. If it is not deliverable, the contract is invalid. Like in this here, we went back, okay. Okay, this is also a very specific condition. It must be owned by the seller and in his possession. This is the merchandise and in his possession. Okay, this is also agent, wakil. It must be known to the purchaser either by sight, if it's present, this is the car, or by ample description, like if I am selling something which is not here, in another city or another state. Okay, you can do that. You can show him the photo or tell him exactly about the details and description of that thing. The model, the make, it has this, everything of that, the mileage, everything. And this applies, for example, purchases that are done over the internet. You might see the photo, the picture, but it still is not like having the object itself in front of you. It's acceptable. But as I said, upon delivery, if anything is missing or not in accordance with the agreement, then you have the option to revoke the contract. I'm talking about the buyer. He has the option to revoke the contract, or he can accept it with, a lesser price. Now, it must be deliverable, which is very important. This is agreed upon by all the scholars. It must be deliverable. Otherwise, it will render the contract as invalid. And it must be determined precisely as to its essence, its quantity, and its value, if it is not present. Okay, this could be, we can add this to the previous one, description, but also the determination of it in a very precise manner. And if you notice, all these conditions to ensure that there will be no dispute between the two parties in the future. And this is one of the most basic objectives of the Sharia, to eliminate enmity amongst people. If everything is clear from the beginning at the time of the contract, believe me, there will be no disputes, no arguments between the two parties of the contract. For the price, exactly the same conditions are applied. The price must be precisely determined at the time of the contract. You are selling this object for how much? 10,000. 10,000 what? $10,000 or euros or Sudanese pounds or Egyptian pound. It has to be determined precisely. It must be known to both parties. In Islamic law, prices are not restricted to monetary price. You can sell a computer for 2 printers, or 2010 car for 2005 cars, for example. It does not have to be monetary price. Money. Yeah. Now, al-khiyarat. What's the time now? 4 o'clock. So, do you need a break? خلاص إن شاء الله. طيب سبحانك اللهم وبحمدك أشهد أن لا إله إلا أنت أستغفرك وأتوب إليك وصلى اللهم وسلم وبارك على محمد. الحمد لله رب العالمين والصلاة والسلام على رسول الأمين وعلى آله وصحبه الطيبين الطاهرين. Now this part is very important, which is the options to revoke the sale contract after being concluded. Now we talked about the essential components and the important conditions that need to be fulfilled. If those things are fulfilled, then we say this contract is concluded contract. Now, do any of the two parties or both of them have any right to revoke that contract after being concluded? The answer is yes. We have major types of options that is available for both parties of contract to revoke the contract after conclusion. The first one is called khiyar al-majlis. Okay, 4 main options. The first option is called khiyar al-majlis. Khiyar al-majlis. Majlis means meeting place. This is the literal meaning of majlis. But we are talking about the session at which the contract is concluded or conducted. Okay, like if the two parties were sitting in one room, this is called the majlis, or one office. Okay, now as long as they are available, both of them, they are available in that place, each one of them has the right to revoke that contract. Like they are sitting in this place for hours, and then after 3 hours of the conclusion of the contract, one of the parties said, you know what, I changed my mind. He has the absolute right to do that. But if he departed from that place, like he went outside to the bathroom and he come back, now that khiyar, that option is expired. Okay, it's called khiyar al-majlis. Now,
so if people are conducting business to do several transactions and they set up a session, they're sitting in a meeting room dealing with different contracts. So they finished the first contract, everybody signed off the contract, and now they started the second session, but they're still sitting in the same room.
Yes.
The contract is done, now we're working on it. Then when you get the second contract, somebody changed their mind. Is that still the majlis?
Yeah, if they did the first...
If they agreed that the first one was the majlis for that contract, and we're done with
the majlis, we're talking about the physical place.
Okay.
Even if they conducted after that 10 contracts, and then after conducting the last one of the two parties says, no, in the first contract, I changed my mind. He has the absolute right to do that. Okay? As long as both parties are available. Even if they sit talking about different types of, issues, as long as they are physically available in the session, in the place, the majlis, each one of them has the right to revoke that contract.
So it's advised, if people are conducting this kind of business, is that they do one session, finish it, break up, take a break, and then come back for a second one.
This could be one way, but there's another way. The second option, which is the option to stipulate a condition. You can stipulate the condition that, okay, I will sell or I will purchase this object from you, providing that none of us has a right to revoke it. This, especially if you think it's a good deal, and you think he might change his mind, you can resolve. We'll talk inshallah later about this one. So the first option is called khiyar al-majlis. Okay? طيب, I'll give you some examples for khiyar al-majlis. طيب. خيار المجلس in contracting between absentees. Okay, like for example, before they use an example, if you are in another city, then I sent you a letter with my offer. Okay, what's considered to be khiyar al-majlis here? We have two people, they are in different locations. Okay, and of course now with the advent of modern technology, people can use fax machines, telephones, emails to conduct contracts. Okay, what is considered to be khiyar al-majlis? When it starts and when it ends. Okay? In this case, the meeting place, when contract is done between absentees, is when the receiving party, the one who received the offer, becomes fully aware of the content of the sent offer, either through the email or regular mail or fax machine. You might send me the mail today, but I open my email, next day. Okay. Once I am fully aware about it, this is considered to be the majlis or the session. Okay. Subhanallah, before they give example of sending a letter. A letter could take like maybe several weeks using that to, then transportations. Okay. But now you can send a fax today to India, split of a second, it is received by the recipient. Okay. But he might not be aware about it. Maybe they receive the fax, after the closure or after they are closed. Okay. But once he was aware about it, this is, the majlis for him. Providing that the acceptance from that person is issued within a reasonable time, taking into consideration, the nature of the contract and the trading customs. This also at the end goes to the accepted customs, okay, in certain locality, okay. So this will determine, what's considered to be majlis and whether they have, the right to revoke the contract or not, okay. But the second type of option, which is khiyar al-shart, is a very powerful tool that could eliminate a lot of types of disagreements that could happen, especially using today's transactions. I'm sorry, today's means, like for example faxes, emails, purchasing using e-commerce or things like that. In the case of e-commerce, using instantaneous electronic devices like instant texting, or or if you log into eBay or place or Amazon.com to purchase an item, okay, what's considered to be the meeting place? For such cases, both of the parties has the right to revoke the concluded offer and acceptance, as long as both parties are still, bargaining through this electronic sphere. For example, as long as I'm browsing, I'm still on that page, each one of us has the right to revoke the contract. But once I departed from that page, okay, to another page or to another site, then that option is over. Okay? طيب. Let me ask you this question, not related to e-commerce or modern transaction. What if I'm working with a brother, two students working together, they came from the classroom and he says, okay, look, I'm going to sell you my textbook for $60. Okay? And the other one, he said, I agreed. And they are talking. Okay? Now, they're still in a session. But if one of them, just moved and went to the cafeteria and then come back, that session is over. But as long as they are walking, it's considered to be the same session. Okay? So the scholars before used to talk about things like that. But anyhow, as I said, the second type of options give the two parties a very powerful tool. طيب. Yeah, when you leave that chat room or when you departed from that website or that page, the option is over. The second option, this is an example. Yeah, if the contract is done over the phone, once the other party hung the phone, then the session is over. In case of conducting the contract through MSN Messenger or chat rooms, when you log out or move to another page, then it is, or when you sign out, then the session is over. The second type of options is called khiyar al-shart, which is the option to stipulate a condition. And this is available for both parties of the contract. Okay? It is the option to stipulate a condition. The word shart in Arabic means condition. It is the option to stipulate a condition that both or one of the two parties has the right to revoke the contract during a specific or a set period of time. جزاك الله خير. يعني for example, Okay, I will purchase, you offered me an object. I said, okay, I'm going to purchase this object, providing that I have a period of 90 days, that during those 90 days, I would have the option to revoke the contract. Okay, or a set period of 1 month. Or it could be for both of us. We can put a condition that, yes, we're going to conclude the contract, providing that each one of us has the right to revoke the contract within 1 month. Or you can say, without any one of us has the right to revoke the contract once we conclude it. Okay, so it's a very powerful tool, just to protect yourself, to give yourself some time, because you are not sure about whether it's a good deal for you, providing that they accepted that contract. So you lay that condition. You set the condition. If the other party accepted, then that's it. Okay, and each one of the two parties has the right to stipulate such type of conditions. Now,
it's modern transactions. It's very common. They say that we offer this thing for this price for this time. If you don't do it, then a different price is going to come. Is that an acceptable shart?
Yeah, acceptable. And for example, they said you have 90 days to return it back, and you will get full payment to the price. In fact, this is khiyar al-shart. This is khiyar al-shart. Now, or you can stipulate the condition yourself. If it's not stipulated, it's not known, it's not the policy of the company, say, okay, I will purchase this, providing that I have a period of 1 month or 2 months or 3 months, you need to return the product if I do not like it. Okay? Not because of the presence of a defect. No. Yeah, because even it's good, it's working very well. But because I laid that condition, then I have the right to revoke that contract, within this period. Okay? Now, when should you stipulate this condition? At the time of the contract?
Before the contract exists.
Before
it has to be before, and people have to be agreeable to it before you establish the contract. Because if you do the shart after the contract is already done.
طيب, any supporter to Brother Kamal?
If your session is over, then it's not valid.
Exactly. You can stipulate the condition before the contract, at the time of the contract, or after the conclusion of the contract, as long as the first option is still available. Why? Because if you have the option to revoke it, as long as both of you are available, you would have the option to stipulate conditions. So you have the right, because if you said, no, I don't accept this condition, then you can simply revoke the contract. So the time for this is either before, okay, or at the time of contract, or while after the conclusion of the contract, and while both parties are available in that place in the session. Now,
so as long as the two parties have the ability to refuse,
exactly,
making the shart is acceptable. But once
they depart,
once one of the parties have no right to refuse the shart, then you can make the shart.
Yeah, in fact, a shart is to extend, your right to revoke the contract beyond the first option. Okay, but you cannot, if the first option is expired, then you cannot lay this condition. You cannot do the second option after the expiration of the first option, which is the khiyar al-majlis. Now, this is the second type of options available to the two parties of the contract to revoke the contract after the conclusion of the contract. The third option, this is what I had mentioned, or before the expiration of the option of meeting place. The third type, which is called khiyar al-aib. Khiyar al-aib, aib means defect. If there is a defect discovered, either in the merchandise or the price, okay, then the affected party has the right to revoke that contract, even after some time, providing that the defect was present before the contract, okay, or before the delivery of the merchandise to the purchaser, okay. And the defect, it must be, the nature of that defect, it must be a defect that usually will reduce the price of that object. Like, for example, if someone purchased a car, okay, for $5,000, okay, and then after purchasing it and taking the car, he found a defect in the transmission of that car, okay. So it's a defect that a car with such a defect, its price will be less than $5,000. Okay, if that is the case, then he has the right to revoke that contract. And the defect, either it is in the, whether it is in the merchandise or the price, because we said the price is not limited to money. If the price is another commodity or another object, if he discovered a defect, a material defect on that price, he has the right to ask for revocation, to revoke that contract. But he has the right, but he can waive that right in exchange of reduction in the price, or he can give the seller an option to take the car and fix that defect, or to pay him the amount that's required to fix that defect. So at the end, it's an option available to that affected party. He can either ask for compensation or ask him to fix it, or he can ask him to revoke that contract. And he has all those options.
Assalamu alaikum. Is there a time frame that you have to bring up this problem that you found with the item?
This is a very good question. No, because some defects cannot be discovered right away. But the most important thing is that defect was present before the contract, before the car is delivered to you. Okay, like for example, if after a while, I did not use my air conditioner. It's too cold now. But after 3 months, when I start using my air conditioner, I found that there is problems with it. Okay, and it is not a new problem. It's an existing problem. Like for example, when I went back and checked the record of that car, or a friend of mine told me, look, this brother, the old owner of this car, he brought this car several times to fix the air conditioning. It has a permanent problem in air conditioning. So, and sometimes it might be very hard to determine. Okay, if that is the case, of course, then it would, the case could be, solved in a court of law. They will do investigation. Okay, at the end, if it was found that this defect is present, before I use the car, then even after a year or so, you have the right either ask for compensation, or the other party fix it, or to revoke that contract. Now,
Assalamu alaikum. Opposite to Khiyar like something is better quality, but it was sold cheap. Like Sayyid Umar radiallahu anhu, he sent a servant to buy a horse, and the horse was bought for 300 dinar or dirham. And then he called for the seller and asked him like why you sold it, and he was like kind of worried, concerned. So Sayyid Umar asked the servant to give him 500 dinar more because it was worth 800. So what is the Islamic law regarding that? Like you bought something that was high quality, and then you discovered that it was sold to you for lower price. Actually, the price should be higher.
Well, I'm not aware about this incident, but in general, like if someone get into a contract, I'm telling you about the opposite, okay? And he was cheated, like, because he does not have the experience or knowledge, and his merchandise worth 1,000, but someone deceived him and he get it for $200, for example. If something like that happens, this will revoke the contract. It will render the contract as invalid, because one of the things that will render a contract as invalid is deception. Okay, if any sort of deception is discovered from the seller or from the buyer, the contract is invalid. Now, but I'm not aware about that story. Now, Allahu Ta'ala alam. Inshallah, when we get to the prohibited transactions, we know that the presence of any of deception, injustice, uncertainty, or riba will render a contract as invalid. Any one of those is enough to, make that contract as invalid. طيب, let me ask you this question. Can you sell anything as is? Is it acceptable? Like, for example, I will sell this car to you as is for $500. So when you drive the car, you find the car has a transmission problem. Do you have this option?
If I accept it as a buyer.
Okay.
Because the condition was put in before the contract was done, and so long as the person who is buying understands and that there is a risk that is involved in it and he exercises that risk, then I believe that the contract would be valid. But if there was no disclosure of all the problems or not knowing the risk and somebody entered into contract, probably not.
Yeah, you are very close. Any additional or any addition to what Brother Kamal says?
There may be chance for deception as well. You said as is, but if you have not disclosed completely, there may be a way of deception there.
I think I know a little bit about this.
Okay.
I think the contract is invalid if there is no full disclosure. Because basically, when you buy something as is, if I am selling you something as is, you have the right to know if there's something that needs to be fixed. Then you can determine whether you want to buy it as is or not. Meaning, if I sell you something for $500, but there is something very bad that will cost you $5,000, okay? And the price of the new item is $4,000, then there's no way that you will buy this thing for $5,000.
So you are saying selling any item as is
without disclosure
is unacceptable without disclosure. This is same like yours, right?
Correct.
Okay. Now the right answer is that it's okay to sell any item as is, providing that you are not aware about any defects on that item. Like, for example, I purchased a car now from the auction. I am not aware about, even I never drove that car, okay? Then Kamal came and he says, I'm interested in this car. I'll give you $100 more or $1,000 more. So I'll tell, okay, I'm going to sell it to you as is, okay? Then this is acceptable because I'm not aware about anything. But if I am aware about something like bad transmission or bad engine, something like that, I must disclose that to you. Okay? So in general, the answer is yes, you can sell anything as is, providing that you are not aware about any defect on that. Okay? If you are not aware, yes.
Or you purposely not disclosing. Basically, no.
Yeah, you purposely, you know about the defect, you have to disclose it.
But that's the disclosure part. That's the awareness part.
Yes.
If you are aware.
Yes.
This is what makes it invalid if you are aware and you kept it to yourself.
That's correct. And because here khiyarul aib, the khiyar of defect. Now, if you are aware about that and you don't disclose it and I discover it, then I have the right to revoke that contract because of the presence of that defect. But if I found a defect and you sell it as is, and it's proven that you are not aware about it, I don't have the right to revoke that contract. Because you took the chance, okay, and the seller was not aware about the defect. So there is no cheating here. Cheating if I know the defect and I hide it. Okay, so you can sell items as is, providing that you are not aware about the defect. Now,
a lot of these things you're mentioning, is there anywhere, like, is there language that is a template or something that we can put into somebody's contract? Or because some of the things you're saying are critical, and if we're entrusted to come up with that language, so like for this as is contract as an example, so as is right now, to the best of my knowledge, there's no defect, right? And written in the contract, if there is a defect that I'm not aware of, right, that this contract is still rendered valid, right?
Yeah, especially here, because you don't have this protection here. If you buy it as is, whether I know about the defect or not, this will not revoke the contract. But if you are in Islamic country or where they apply Islamic rules, and I don't know where, but if they apply Islamic rules, in all aspects of our lives, okay, and this happened to you, then this contract is invalid, and this will be invalid contract.
No, I got it. No, I'm with you in the fact when we're not dealing, like if I'm dealing with another brother, right, then we can use these kind of contracts, right?
Yes.
But obviously when we're dealing with any of the other non-Islamic entities, well,
So
obviously they're going to have different contracts.
now here you have the option to lay conditions. I purchase this, providing that you disclose whatever you know about the the defect.
That's what I'm saying. If for between Muslims, is there any Islamic contracts that we can, as a guide, for us to establish these?
Yeah, of course. All those options and conditions. If you go to any book of fiqh, when they talk about business transactions, you find talking about the conditions. They might not talk because it's not a non-transaction at that time.
Right.
Okay. But the scholars, the contemporary scholars, when they studied, modern transactions, they try to figure out, using the knowledge they have of the conditions and these things, to come up with those things. But it's all over the books of fiqh. No. If it happened between Muslims, then it would be easy. If they come, for example, and seek judgment for the Imam of the Masjid, he must apply those things. But if it is with non-Muslim, of course, the secular law, is not. I don't think there's a protection for someone who purchases anything as is. But for a defect, if the presence of the defect, I think, you can return it or you can ask for compensation.
They call it the lemon law, but I don't know if it pertains between two divisions.
Okay. طيب, the fourth type of option to revoke the contract available to the two parties or to one of the two parties is called khiyarul ru'ya, which is the option of viewing. And this is mainly when you purchase something which is not present. You purchase it on a specification. They give you the specification of this item, and upon reception of the item and view it, you find mismatch between what offered and what delivered. If that is the case, you have the full option, either to revoke the contract or ask for compensation. Okay, especially if you purchase an item over the internet or any type of purchase like that, then upon delivery, if it does not match the specifications or the description offered to you, then you have the full right to revoke that contract.
The revoking of the contract on that particular aspect is because they did not disclose, basically, because they told you that it's a white car or whatever, but they didn't disclose all the things about it, and then when you saw it, you saw that there were some things that were missing. But if they describe it and everything that they described was there, do you have the option?
Yeah, you purchase the car based on the description given to you.
Right. And if every part of that description was there,
خلاص,
the ru'ya doesn't work.
خيار ru'ya does not work. Now what works is خيار العيب.
Right.
خيار العيب, now if the defect found in that car, usually for a regular, like for example, for say Toyota 2008 or 2010, expected to have good transmission, right? Good engine. Okay, so everything matched, but you find a defect on the transmission. Usually such a defect will reduce 2008 to 2008 Camry from saying being $6,000 to be $4,000. Okay, and you paid $6,000. Then you have the right to revoke the contract.
A better example of that is that they show a picture of the car from one side and they don't show you the other side, and there's a huge accident damage on the other side. For example, that would be a perfect example of khiyar ru'ya, because you don't see the whole car.
No, this is not khiyar ru'ya here. The part you see and convince you to purchase this must match. Now the presence of that damage usually reduce a price of such a car from 6,000 to 4,000. Now then you use khiyar al-aib, because it's a presence of a material defect that would reduce the price of that a similar car. But if it's like just all the scratches, okay, then that will be acceptable. Now, But the part that's shown to you, it must match. If you find the defect on the scratches or in that part shown to you, then of course you have the right to use khiyar al-ru'ya. Wallahu ta'ala. طيب, prohibited transactions. This is, very important part of business transaction in Islam. It talks about the transactions that is prohibited for a Muslim to get in, or in other words, not only to get in, that what would make a contract invalid. Okay, a contract that fulfills most of the conditions, but absence of some conditions or presence of things in that contract will render it as invalid. Okay, as I mentioned earlier, there are things that if it is present in a contract, it invalidates that contract. Injustice, zulm, in Arabic zulm, deception, which is called al-khadi'a. Okay, gharar means uncertainty. Okay, and riba, which is usury. The presence of any one of those four elements will render that contract as invalid. Whether the rest of the conditions are fulfilled, even with mutual consent of the two, the legal competence of the two parts, every condition is fulfilled, but one of those four items is present, the contract is invalid contract. Type examples for prohibited transactions. Type the sale of non-existing items, bay'un ma'dum. This is the issue that we discussed earlier. To sell something which is not in existence. Okay? Now there are certain things that is agreed upon by all the scholars that you cannot do it. Like, for example, to sell something that is not in existence, and its existence is not most likely we think it will happen. Okay? But if such type of object usually or most likely would exist, for example, at that time. This is here where we have the disagreement between Shaykh al-Islam ibn Taymiyyah and those modern contemporary scholars and the early scholars. Okay? If it is not in existence now, but most likely it exists, okay, then it could be a subject matter of a contract. It could be sold. Okay? But according to the majority of the scholars, especially early scholars, non-existing items cannot be sold. If it's not in existence, you cannot sell it. With the exception of bay'us salam, or the contract of manufacturer. When you go to a tailor to make a soap for you, you can pay him the money, and then he can even you can pay even the soap is not in existence now. Or you go to a builder to build a house. They made those an exceptions. Okay, but something that is not existing, you will go and buy it and find it and then sell it. According to the early scholars, it is not acceptable. According to Shaykh al-Islam ibn Taymiyyah, he says, not because it is not existing. The question must be, is it deliverable or not? If you can deliver it, or most likely will be able to deliver it, then it could be a subject matter of a contract. It could be a merchandise in a contract. طيب. Ensuring something which has never taken place yet. And this could be an example for this. The prohibition of this type of sale is agreed upon, in fact, not by all the scholars. Here, when I said all the scholars, I'm talking about the early scholars. In fact, not all of them. The vast majority of the scholars. Because even among the early scholars, some of them, they said, what matters is the deliverability of that object, not whether it is existing now or not. Okay? And as I mentioned earlier, when we say the four imams, even if the four imams agreed on one thing, it does not mean that every other scholars agreed on that. There are other imams who are not famous and known to everyone. They might have different opinion or different position than their position. But those four imams are the famous one, and everyone, even the general people, lay person know about them. But no one knows about Al-Awza'i. He is not less than Abu Hanifa and Malik and Ahmad ibn Hanbal and Shafi'i, Sufyan al-Thawri, and Layth ibn Sa'd. Those are great imams and scholars. Sometimes they might differ with those four imams and their opinion adopted later on by someone like Shaykh al-Islam ibn Taymiyyah or other scholars. Okay? طيب. أيوة. السلم and al-istisna. Al-istisna is the contract of manufacture. You know, like you ask a manufacturer to manufacture a car to you with this specification, or a builder to build a house with this specification. طيب.
Question about that.
Selling an item before one actually takes possession of it. It is not in your possession. Okay, so you cannot sell it. Now, what's your question?
My question was the salam and istisna. It seems like what is permissible is something that is maybe a tailor can known to be able to make a certain type of thawb. For him to deliver that, it's just a matter of him putting the time. It's not like he's going to invent a thawb. But R&D, research and development, if you're asking somebody to invent something that does not exist, maybe that gets into the prohibited areas. But to build a car, a Toyota Camry, it's not here, but they have made it before. It's doable. It can be made.
Exactly. So it could be delivered. Most likely, such a car with such a specification would be delivered. But if you ask one to make a car that flies, you know, and like maybe, you know, so what matters here is it most likely could happen and be delivered or not. Okay? If today's technology would allow something like that to happen, then it could be deliverable, most likely, even though it might not be, you know, exactly matching the specification. Okay, so the question must not be whether it's in existence or not. The question must be whether it is can you make something like that and deliver it. If the answer is yes, then it could be a subject matter of a contract. طيب.
So can we just one more around insuring something? I think you gave the example insuring something that did not happen. So that kind of put that transaction of a vehicle insurance.
Yes, inshallah, when we get to modern transaction, we're going to talk about insurance. Insurance, you know, in general, insurance is prohibited because it involves uncertainty. We said the four items. You said deception, right, which is al-khadi'ah, right? And we mentioned also uncertainty, which is al-gharar. Now for insurance, you know, there is quite a great deal of uncertainty. You might, you know, pay your installments for years without having an accident. And one might just pay one installment and next day get an accident, get compensated for $5,000, $10,000. So there's a great deal of uncertainty. Okay, but there are some exceptions. We're going to talk about those exceptions, inshallah. Probably tomorrow we'll talk about modern transactions. Okay, especially with life insurance, whether it's term life insurance or life insurance in general. It involves uncertainty and riba. Life insurance involves both riba and uncertainty. Riba because people pay less and the beneficiary or the family will get more. Yani 1,000 or 500,000 policy, he pays like $60, right? Even if he continue paid for 200 years, you know, he will not reach the $500,000 policy, right? So this is riba, because riba is, you know, you pay less, you get more, okay? Plus the uncertainty. Yeah. So insurance in general, whether it's automobile insurance or health insurance, because it involves uncertainty, you know, it is prohibited in general. But there are some exceptions. There are some exceptions. We'll talk to them. Inshallah.
Is this when we talk about leasing, or is that later?
Leasing, like leasing a car, leasing software.
No, you know, leasing. This is we said the contract of exchange. Either you exchange a commodity for a commodity or money, or a commodity and money for for a benefit. Okay.
منافع.
Now leasing is a benefit.
منافع.
So هي منفعة. Now you are leasing a منفعة. يعني you don't own the car.
Right.
The lease car, but you own the right to enjoy it for a period of time, which is like three years, for example.
So leasing is not haram.
No, it's acceptable leasing.
A car is not haram.
ما فيها شيء نعم. طيب, the sale of undeliverable items, which is called بيع المعجوز. Anything that undeliverable, of course, it cannot be a subject matter of a contract.
Sheikh,
No.
about leasing the car, you said it's halal, but if you go into the detail,
Okay.
if you lease a car, they charge you $14 or $15 per $1,000 borrowed. What's that?
I'm sorry, what's that?
When you lease a car nowadays, they say they will charge you $15 per $1,000 borrowed. That's riba. And they put that amount in your payment.
Okay.
Even though you are leasing, right? They put that amount in your payment. What's that?
And I don't know about that.
It's riba.
Sheikh, there's this was something that I actually studied. So there's a formula.
Okay.
It's an algorithm.
Okay.
And they call it a leasing factor.
Okay.
And the leasing factor
To determine the amount of payment, right?
is the equivalent of interest. So what it is leasing. How they do it is the lease amount that you're paying is the depreciation on the car. So you're actually paying for what the car would depreciates. Now they call it a lease. The renting a car is different. So this is different, right? Renting a car we know is okay. But leasing a car has an algorithm and it has a leasing factor. And
But this algorithm is to calculate how much you pay, right?
Correct.
Through the lease period.
Correct.
Okay?
Correct.
Now the contract that I'm doing with them, regardless of how they calculate it, how they come up with paying $1,000 down and $200 every month for I must not concern with that. Okay. What concerns me is the contract between me and them. In that contract, I'm leasing this car, okay, for 3 years, for this much amount of money. Part of it paid in advance and the rest paid in installment. Just like, for example, the deferred sale. البيع المؤجل. Look, I want to sell the car to you. I'll tell you, this car for $1,000 if you pay me now. If you want to pay me over a month or 6 months, you pay me $2,000. Okay? Now, before the conclusion of the contract, we have to agree on one of the two plans. Whether you want to pay me $1,000 now or $2,000 over 6 months. If you agreed that you pay me $2,000 over 6 months and we conclude the contract, now, this is acceptable.
Oh, it is, okay.
But here, look, here, a condition has to be fulfilled. That this $2,000 becomes the final price of that car. Whether you pay me in 6 months or if, subhanallah, Allah bless you with like a ward, okay, and you want to pay me next month, you have to pay the $2,000.
I see.
It becomes a final price.
I see.
And by the way, al-bay' al-mu'ajjal is very good to the dealers because it is better. It's better than the interest. Because if you are paying interest, the earlier you pay, the less you pay.
Correct.
If the deferred sale, Islamically deferred sale, then you pay the final price, whether you pay it in a month or 2 or 6 months.
I see.
Okay. So how they come up with the final price, this must not,
I see.
I should not.
That's not our.
What concerns me is the contract that I'm doing with you. Okay. This car lease for this much amount of money. This part of it paid in advance and the rest paid over.
So let me ask you something, because so now you bring up another scenario related to all of this, right?
Okay.
So let's just say right now my friend goes and buys the car, right? and he gets a loan, right? He doesn't lease it. But then he says, hey, listen, I'll lease you the car, right? And it's a fixed payment. The contract that exactly that you're saying, it's a fixed payment, regardless whether you pay early or not. This fixed amount is what you're going to pay.
Okay.
Right? But I know that he bought it using riba. Is this acceptable, or that it doesn't matter to me?
There's two different issues.
Mm-hmm.
Okay, because if we said if he gets it through riba, then you cannot purchase it from him, to make people's life very hard.
Mm-hmm.
Okay, you know what matters? The contract between you and him.
I see.
Okay, now he purchased through riba, it's his problem, and he will be held accountable for that.
I see.
طيب شوف the Prophet صلى الله عليه وسلم and the companions, they used to deal with the Jews in the Medina with different type of transactions, right? The Prophet ﷺ once borrowed food, okay, borrowed, and he had his shield as a mortgage for that, okay. Now Jews are known to get their money from riba, okay, so it's haram for them, but for us, you know, if you deal with that person in a illegal transaction, then it's okay. Yani, for example, if you know someone who won lottery, for example, okay, and you work as a mechanic, you fix his car, and he give you your money from that. You know, it's haram for him, but it's halal for you because you get it from him through a legal transaction. Okay. Otherwise, you know, none of us has legal salary here.
Right.
Yes, because you don't know your company where you. As long as the line of business of the company is halal, and you do a halal job, whether they get it from a loan, from wherever they get it, is not your business. It is their business. Okay. So this is very important point. I think there is a question about this later on, inshallah. Okay.
Now, about the leasing of a car. Now, I understand what you said, but if during the leasing process, the dealer wants to fill out a loan application.
No, you should not do that.
Right?
Yes.
Because I don't know how they do it. Because alhamdulillah, I haven't borrowed any money. I don't have any mortgages. Alhamdulillah. I don't know, but it seems to me there must be a process of applying a loan because of lease. I don't know.
Well, you know, so the lease process, it's not the same paperwork as a loan. They do check your credit because they want to know that you're capable of paying, right?
That's your credit worthiness.
Exactly.
Yes.
And they find out what kind of job do you do and how much do you make, right?
Yeah.
This stuff they do, right? But the contract you sign is specifically you're going to make this payment this many times, and at the end of this time, the car comes back to us.
Yeah.
Or if you want to continue, then you purchase it at that time.
That would be a different story because now the first contract is ijara, is lease contract.
Correct.
Upon the expiration or termination of that contract, then if you want to purchase the car, this is another contract.
Correct.
So this part, wallahu ta'ala alam, I don't think there's anything wrong with it.
Okay.
Okay. How they determine the amount of lease and these things, up to them.
Right.
But they must come to me with a price.
Because in these contracts, in a mortgage, they have something called an amortization schedule, which shows you how much interest you pay and how much principal, right? And I think you're going to cover this.
This is for purchasing.
This is for purchasing, right?
Yeah, but for leasing.
But when you're leasing, they don't do that.
Yes, okay.
They just have a fixed payment for this many months. This is how much you're total going to pay.
Yeah.
Right? And then at this time, this contract is expired. That's it. You return the car.
That's correct.
And what happens is they do an inspection, make sure that it's the normal wear and tear is okay.
Yeah.
All
that is acceptable.
Yeah.
Because you don't own the car.
Right.
They own it.
Correct.
So if any damage, for example, happen to the seats,
I have to pay for it.
Yeah, you have to pay also the mileage.
Exactly.
So that's acceptable.
That's exactly.
Because I can rent my apartment and I can lay conditions.
Correct.
Okay. But you know, if it's a like sale contract, you know, I'm the owner of that car. Correct. So I'm not responsible for damages or things like that. It's because my car now.
So just to make sure, as long as while you're leasing the car, you don't fill out a loan application, it's correct. Okay.
Yeah. What matters the contract between you and them. But how they come up by that price, what algorithms they use, you know, at the end they will come with a price.
Now there is one thing that when he says, and I don't have the microphone. A loan application is exactly what I just described to you.
Yes.
They do a credit check.
Yeah.
And they make sure that you're able financially to pay it. It's identical to a loan application.
But it's not a loan application.
Correct.
Yeah,
but
that's what matters.
Yeah, they have a form you have to fill out. This it's the same exact thing.
Yeah, you get the social security number. They check,
your address,
yes.
your job, how long you've been working there, what's your income, who's your supervisor, blah blah blah. So this is typical.
Yeah, even if they call it.
What's the difference of this application and the loan application?
No, a loan application, you apply for a loan.
Right.
Here, there's no application. You know what matters? Is the reality of the thing, not the name. The Prophet ﷺ says a day will come and the people, they will call al-khamra with a different name. Now they call it spirit.
Right.
The name does not change the reality of that thing. Whether they call it loan application, if it is not an application for a loan, whether they call it loan application or not, it doesn't make difference. But most likely they do that to check your credit worthiness.
The loan application that he's referring to is the final executable contract that makes it a loan. Until you sign it, it's not a loan, right? So that contract, they call it a truth. What's that?
No, for the lease. Now we're talking for purchasing or lease.
No. When the brother is talking about the loan contract, right?
Yeah.
You don't. The only time you fill out a contract is to actually execute it, which makes it active, right? Okay. So when you're filling out the information, says I work here, I live here, this is how much I make, this is my credit score, blah blah blah. This is just authorizes them to do their due diligence to make sure that you're capable of paying, right?
Yeah, but there is no loan involved at all.
Right, and you're not liable for anything. There's no liability in that.
Yes.
Right? The next contract, once they see that you qualify, right? Then there's another contract.
Yeah.
If you're buying the car,
then they will
finance it. There's a loan contract which says what your interest rate is, what interest you're going to pay, in a lease, that's not the kind of contract you get. So the loan application is different than the loan contract.
Yes.
Right? The loan application just is to qualify. Once you're qualified, then there's the actual executable contract.
Yeah.
That's the one that what the Sheikh is saying is haram.
Yeah.
Good.
What if you missed the payment when the contract started? If you missed the payment.
Yeah, so in most cases,
late fee.
They have a late fee, exactly.
Late fee is riba. But late fee, if you are late in paying your rent, you will pay it. If you are late for paying your your water bill, you will pay it. So now this is your responsibility to make sure that you will not be late. Okay? In fact, they must Islamically, late fee is not acceptable. If you are dealing in Islamic transaction, you cannot impose late fee because of form of riba. But here it's not in our control.
Well, what they do is related directly to the late fee is 5% of the payment. 7%.
Even if it is flat, it's not acceptable. Late fee is a form of riba because you're paying that because you did not pay on time. Yeah, it's like $1,200 your rent. Okay, if you fail to pay it before the 5th of the month, then they will apply it.
Correct.
Okay, this is the concept of riba. I lend you money, if you did not pay me on time, then I will apply interest. But this is a Muslim. If there's a Muslim financial institution, they should not apply late fee. Okay, but here it's not under our control, and you can pay it even if you fail to pay your utility bill.
Right.
Okay, so it's not only applied to lease or this is for everything. Yeah.
So let me just ask a couple of questions in a different way. The whole concept is what we call, or what is being called, is hedging and protect. Hedging is meaning there's a value, and the value will either depreciate or increase in value, right? So in the Islamic way, if I come in and I say, this is the house, it's worth $300,000, but I'm going to come and I sell it to you for $600,000, right? I'm hedging that $300,000 because by the time you paid in 30 years, that $300,000 that I'm paying, I'm hedging, it's going to be worth, it should be at $600,000.
Not for that. Even you can ask for more and add profit.
That is correct.
Yes.
So now, and bear with me. I'm a bank. Okay? I come and tell you the same concept, but I call it interest.
No, it's not the same concept.
But it's the same concept because I'm still, at the end of the day, I'm paying, you're going to pay $600,000. Or $300,000. I'm just trying to understand that because a lot of people asking the same question. They say an Islamic bank is going to take this house that is worth $300,000. They going to charge me $600,000 by the end of 30 years, right? But let me finish. So, I know, but that's the transactions we're talking about. That's the concept of lease.
لا it's different.
It's the concept of loan.
طيب يا جماعة أنا widely understood your point. Okay, there is a difference between deferred sale and a riba-based transaction. And I will show you. I'll give an example. Okay, I will tell you this house. If you want to pay me now, it's $300,000. If you want to pay me over 30 years or 15 years, it will be $600,000. Okay. The very important condition to make this Islamically correct, that once we agree on $600,000 as a price for this house over 30 years, it becomes the final price, whether you paid me in 30 years or 15 years or even tomorrow. Okay, this is very important. And this is on. Inshallah, we're going to talk about the deferred sale. Inshallah, later on. This condition has to be fulfilled. The second condition, in the wording of the contract, there should be no mentioning that relate the final price to the time. Okay? And this is why I'm saying the deferred sale option is very good to banks. Because in a riba-based bank, the earlier you pay off your debt, you pay the less. In this type of contracts, whether you pay earlier or on time, you're going to pay the $600,000. So it's very good to the seller. Yes.
It's not good for the seller.
It's good for the seller because whether you pay me, I mean the owner of the car, okay? So whether you're going to pay me in 6 months or now or tomorrow, you pay the $600 that price you agreed upon. Now. Okay. طيب خلاص. Type inshallah. Let's go inshallah to the fourth type of prohibited sale. This is called the sale of al-khadi'a, بيع الخديعة. خديعة means deception. Okay? صلى الله عليه وسلم يقول من غشنا فليس مننا. So it's very important principle and it will render the contract as invalid. Like example for this is someone who is not expert on prices and he sold something that was $100 for $20. Because out of his ignorance, and the other people take advantage of that. This is an invalid contract. Okay, this is an invalid contract. And also deception include other type of things, like some person who hide defective items from, and you want to also selling something as is, knowing the defect on that. This is also considered to be bay' al-khadi'a, and it's also unacceptable. طيب, here's the sale of al-misarrat. This is also a deceptive, one of the example of deception. Al-misarra, you know, sometimes before when they are selling an animal like a goat or a cow, you know, they you know, this animal was not milked for certain days, for some days, okay, to make it look that it has a lot of milk. Okay, so the one purchased it, you know, after just the first milking, then he found that, you know, it does not produce that much milk. Okay, it was mentioned in the hadith, the Prophet said that he has the option either to return it or ask for compensation. Return it means to revoke the contract or ask for a compensation. Okay, so this is also a deception. Okay, another the bay' of al-muzabana. Muzabana is to sell the fruits of, like, for example, a date tree or any fruit producing tree, like to sell the fruits on the trees for dry fruit, because there would be a difference, because dry fruit usually, less weight than fresh fruit. Okay, because it's also involve uncertainty and also some type of deception. Okay. Another prohibited or forbidden prohibited type of sale is selling forbidden commodities of like liquor or musical instruments and things like that. It is prohibited because anything that Allah makes prohibited, we cannot sell it, we cannot trade it, we cannot rent it, it could not be a subject matter, a price or a merchandise in a contract. Type sale of images and pictures and things like that, images of living beings. Okay, sales of tapes or CDs in which are recorded, immoral songs and things like that. Type sale.
So amongst the I guess forbidden things, this is the sale of forbidden things, or this is what's forbidden that makes it right.
Yeah.
So selling a unforbidden thing to like Department of Defense as an example, is that covered later, or
unforbidden things?
No, unforbidden things.
Right.
I'll
give you the general principle. Then you use this principle and apply it for many cases and issues. Okay? The principles stated in ayah. Allah says, وَتَعَاوَنُوا عَلَى الْبِرِّ وَالتَّقْوَى وَلَا تَعَاوَنُوا عَلَى الْإِثْمِ وَالْعُدْوَانِ. The second part of this ayah says, do not help each other in doing ithm and udwan, evil or transgression. Okay? For example, the scholar said, selling grapes, is it acceptable or not? If I'm a farmer, I'm selling grapes. But if I know that a specific person, he used grapes to make liquor or khamar. Selling weapons is acceptable in Islam. But the scholar said selling weapons at the time of fitna is haram, because Muslims will go to purchase to kill each other. So you use this golden principle. So you ask yourself this question: getting involved in this transaction, is it promoting evil, or it is accepted? I mean, it is halal to do it, or it will result in something haram. Okay, you apply this whether you're selling your object to the Department of Defense or the Department of Energy, or even sell it to the Department of Health. Okay, what matters, are you contributing to evil or you are contributing to good? Okay, and many people ask me questions. Okay, I'm an IT professional and I write applications and programs to a bank or insurance company or such and such agency. Ask you this question: by doing this, you are promoting evil or promoting good? Okay, installing, for example, cables, dish. I mean, you ask this question. Now we go by most likely the case, this will be used for good or bad. Selling computers. Most likely computers are used in a good way. Okay, so it says acceptable to do that. Okay, but selling something that most likely will be used, to promote evil or, to promote aggression is unacceptable. Allah Ta'ala. Did I answer the question? Unacceptable Islamically, yani. Unacceptable means it's haram. Islamically unacceptable. It's a golden principle. اتفضل sister, go ahead. Okay.
About selling the service, about being used in a good or an evil thing. If the service is, let's say, if someone represents the service or presents the service as good, but you have a doubt in your heart that it will be good, what happens?
دع ما يريبك إلى ما لا يريبك. If you are in doubt, then go for it.
I mean, like, I cannot be very explicit about it, but the service itself, the device, the machine itself, it is good.
Neutral.
It is good, but something in my heart says it will be used for something else. So you just leave it alone.
No, unless you have a proof, or you think most likely, or such equipment or such device usually or most likely will be used for that. I'll give you an example of a computer. Computers are most likely used for something good and beneficial, right? But some people might use it for something bad. So it is acceptable to have a store where you sell computers, okay? So just use this rule. Okay. Am I promoting evil by doing this, or I'm doing good? Sometimes it could be easy to tell. Now, if you are in doubt, okay, because the information you have could be equally 50-50. The Prophet ﷺ يقول دع ما يريبك إلى ما يريبك. If you are suspicious and you feel comfortable, or you think most likely, or there is 50% chance it will be used in evil, then leave it. But most likely it's used in good, like computers. So you can have a store to fix computers, to sell, purchase computers. Okay.
Assalamu alaikum.
Alaikum salam.
Brother, what about the Muslims that work in alcohol restaurants or grocery stores as cashiers or waiters?
Well, that's a problematic. This issue معضل. It's problematic. Now, if you work in a store, like say for a store, but you work in a department that does not have to do with, you just pack fruits and vegetables and things, that's acceptable. But if you work in a department where you would be selling alcohol or backing them or things like that, then of course you should not do that. The general principle, is do not help each other in doing evil in any capacity. I will tell you something. Now, riba-based banks, a Muslim cannot work in a riba-based bank, because the Prophet ﷺ says, لعن الله آكل الربا وموكله وكاتبه وشاهديه. The loan officer, the witnesses, okay, the one who gives the riba, the one who take it. And the Prophet ﷺ says, قال هم في الإثم سواء. They are equal. Okay. Now, working as a teller is not like working as a loan officer. Okay. But still, the teller will share part of the sin. Now, the one who mops the floor and fixes the air condition for the bank, he will share part because he's promoting the evil. He's not like a loan officer or the one who make advertisement and call people to take loans. Okay, that of course will get a big share. But at the end, working also as an IT professional, writing applications and programs, it will help in promotion of evil, whether it's a computer, like a company, insurance company. And for our brothers, who work in this field, they have to be very careful. Very, very careful. Many brothers, they come and ask me about, can I work in this job? We have a contract.
Assalamu alaikum, brother. What about the insurance company, the people that are financial analysts and working for the insurance company?
Yeah, exactly. Financial analyst or an agent, or just an electrician who fixes the air conditions for that company. He shares that part, because insurance in general, as I said, is prohibited in Islam. I'm talking about the secular type of insurance, because there is a Ta'min al-Ta'awun, is a cooperative insurance that's implemented in some of the Muslim world, some Muslim countries, that's acceptable. Okay, but the insurance that we know, like here in this land, is absolutely haram. But there is some exceptions to have it, to have like liability insurance, or sometimes even full coverage, if mandated and you cannot go without having it. Okay, when we talk about insurance, we have all the exceptions. But in general, you cannot work and participate in any capacity. Okay, and people will bear different, portions of the sin. Yeah, the one who is in direct contact with the riba contract itself, of course, he bears the big sin. But the one who like a security guard who guard the bank is not like a loan officer. A teller is not like a loan officer. Wallahu ta'ala alam, yeah. We have to remember all the time that our presence in this land, in general, in any land, even at your home country, okay, you should ask yourself this question: am I able to preserve my deen, my family's deen, my wife, my... Okay, if the answer is yes, then you can reside and stay in that place, whether it's in America or Europe, or sometimes in your hometown, you might not be able to practice Islam like you practice it here. Okay? What matters is, am I able to practice my deen? Anytime you find out that there is no way for you to practice your deen, whether here or back home, then what should you do? Migrate. And there is a concept in our minds which is not correct, you know. Yes, people think, you know, where the place in which you were born, you have to die in that place. No, you don't have to go back to the country where you were born. You know, the determining factor is that where I will be more pleasing to Allah subhanahu wa ta'ala. This should be your hometown and your home country. If you are pleasing more to Allah subhanahu wa ta'ala in a place, this must be your place. Okay? Wallahu ta'ala ajallu alam. There are some examples of, you know, types of sale which is not existent anymore. But I will give it like bay'ul hasa. Bay'ul hasa, that the merchant will ask you, take this bible and throw it. Okay, whatever merchandise it land on, then it's used for such and such. This similar to what, like sometimes, you know, some vending machines, you put quarters and there are different types of, you know, toys with different prices, different values. This is not acceptable, because you might put the quarter, yes, it's just like gambling. Okay, because there's uncertainty. You don't know whether the bubble will land here or land on that merchandise. Okay? But they used to call it bay'ul hasa. Hasa means a small bubble. It is similar to those type of vending machines. Throw this bubble and whatever merchandise it lands on, it's yours for such and such price. This is prohibited. Type sale of النجش. النجش صلى الله عليه وسلم قال ولا تناجشوا. Do not practice نجش. نجش is in auctioning. When someone bids up the price, not with the intention to purchase, but with the intention to raise the price. Either, you know, he's working with the owner, or he just want to harm other people. Najas is haram. Okay? So if he bids up the price without the intention to purchase, only to harm that brother, or because he's working with the owner, he want to raise it, this is haram and invalid and is prohibited. It's called bay'un najash. In a public auction, then a person bids up the price of that item without having the intention to buy it. It's called najash. Yeah.
So the auction in itself, if the intention is
it's
pure,
okay. Yeah.
it's acceptable.
Yes.
Okay.
Auctioning, which is called bay' al-muzayada. In auctioning, is different than the regular sale, that the price is offered by the purchaser. It could be one purchaser or more than one. I have the computer, you said $100, so you offer the price, not me. Okay, then he bids up the price and he said 120, 130, you know, this is acceptable. No.
Does that auction is part of the requirement for that auction to be halal is the seller to refuse to sell? Say he wanted to put the computer on the block for sale, and the only thing that he can get for it is $100, but he put in his mind that he's not going to sell the computer until it brings 200. Is he forced to sell it for 100?
No. Because at the end, there must be a mutual consent.
Right.
If he accepted the price, then if he said no.
But some of these auctions, they sell it for whatever it brings. It doesn't matter. And the seller doesn't really have a choice.
If you enter such a contract knowing that you have to sell it for the lesser, whatever price provided, that would be acceptable. This is like a consent. Because I brought my car to be sold in this knowing that, you know, I don't have option to, yes. And usually people, if they have a good car that worth something, they won't bring it to the auction. Because he can find easily someone to sell it. This is about bay'un najash. The sale of al-'ina. Rasulullah says a day will come قال وتتبايعون بالعينة, which means that something which is not acceptable in Islam, bay'ul ina. And bay'ul ina is prohibited. And this is when a person buys something from someone else on credit, okay? And then selling it back to him for a lower price, cash price. This is a trick for, getting a loan, a riba loan, okay? Like, for example, and some people, unfortunately, they are doing this, okay? It's called tahayul. It's a trick. Like, for example, I purchased a car from you on credit for $12,000 paid over 6 months. And I will resell it back with a prior agreement between us that I will resell it back to you for $10,000 cash. So I end up, the car comes back to you. It ends up that you are lending me $10,000 for $12,000 paid over 6 months. So it is hila, it's a trick that you use for riba, okay?
Just to get the cash?
Yani, for example, you need $10,000 cash, okay? So you go to a dealer, you purchase a car from the dealer on credit for $12,000, okay? Paid over, say, a year. And then immediately you resell the car back to the dealer for $10,000 cash. So you will get the $10 from him, and you owe him now $12,000. So it's riba, but it is a trick. Now there is a different thing which is called tawarruq. A tawarruq is to purchase a merchandise on credit and sell it in cash to somebody else, not to the owner. This is acceptable. A way to get cash without getting involved in riba. I purchased the car for $12,000, paid over a year. I'll take the same car and sell it to a third party, not to the same person, not to the same bank, to a different party for a lesser price.
And in the case that you're describing, is a person is in need for money now.
Yes.
And he's basically doing a losing transaction. He's losing $2,000.
Exactly.
But in the other case, he's actually from very beginning, he went to that person to give him 10,000, but he wouldn't give him the 10,000 unless he gives him 12 for it. So he tells him sells him the car in paper, and charge him 12,000, and he sells it back to him for 10.
Yes, and al-'ina is prohibited, and unfortunately, it's practiced. Subhanallah, even in many Muslim countries, they use it. Merchants, they use this as as hila for riba. In fact, it's clear riba. But you take it and then you go try to sell it. Make an effort to sell it. Try to sell it for a good price. If you can get for 10,000, I will sell it. 11,000, I will sell it. That will be acceptable. But it must be to a third party, not the same party. Okay, this is called tawarruq. Okay, this is a modern transaction which is practiced also by many. I know of many brothers from Saudi Arabia, they get cash money through tawarruq. Now, طيب, buying or selling after the second call of a Jum'ah. Allah subhanahu wa ta'ala says, الذين آمنوا إذا نودي للصلاة من يوم الجمعة فذروا البيع. If you conducted a contract at the time of the adhan of the second adhan of Jum'ah, that contract is invalid. Okay? Because after the second adhan, right away.
Which is the khutbah, it's
the
salah.
Exactly.
You're talking about the salah, not the khutbah.
No. Usually some masjids they make 2 adhans of Jum'ah.
Right.
The first one is early, even before the time of Dhuhr. The second one, after which the Imam will start the khutbah right away. Now it's prohibited after this adhan to conduct any business contract.
Okay, but so one quick. So like in this land we have some masjids that have multiple Jum'ahs, right?
Yeah. Now the Jum'ah that we're going to pray.
Yeah,
okay. And pray the second. Usually some masjids they have a Jum'ah before Dhuhr prayer, which is a controversial issue among the scholars. The majority of the scholars that you cannot pray Jum'ah before Dhuhr. Only the exception is Hanbali madhab that you can do it before Dhuhr. And the stronger opinion that you cannot perform Jum'ah before Dhuhr. So just to be on the safe side, if the masjid has more than one Jum'ah, pray the one that
is
after Dhuhr.
So the illah for what you described here is that the if there is a illah, it's the khutbah is part of the Jum'ah prayer.
Yes.
So once that second azan is called and the khutbah started, you should be in the prayer.
Yes. Because right after the adhan, the khutbah would be.
Right.
Yeah.
And the khutbah is part of the Jum'ah.
Exactly. Yeah. And Allah says, فَزَعَوْا, rush and hasten to the remembrance of Allah, which is the khutbah. So no contracts would be done. Also, a prohibited transaction is a brother selling against his brother in Islam. How? Someone might say, okay, Tab, you said auctioning is okay. What's meant here, like if two brothers are concluded the contract, but they are still in the same session, okay? Then I came to the seller, I tell him, okay, look, I will give you a better price than his. Now they already concluded the price, and they have the option to revoke the contract. Now this is prohibited. It's prohibited. But before the conclusion of the contract, he has a car, he offered it for 10,000. I tell him, I give you 11,000. That's acceptable. This is not selling against or buying against my brother purchase or my brother selling. No. It's meant after the conclusion of the contract and the two are available, where the two have the right to revoke the contract. Then a third party intervene, either to give the seller a better price or come to the purchaser and said, I'll bring you a better car. Okay, this is haram. The Prophet ﷺ says, قال ولا يبيع الرجل على بيع أخيه لا يخطب على خطبته. A Muslim cannot engage or propose to a woman who is already engaged to another Muslim. And he cannot also sell against the sale of his brother.
Yeah. A question about the Jummah Adhan. Many masajid, they don't have the second Adhan. So in this case, is the
No, they have the second Adhan, but not the first Adhan. Okay. The second Adhan is the major Adhan, after which they start the khutbah right away.
So in that example, from another Muslim, let's say in that example that the other person is not a Muslim.
Wallahi, so type, if he's a non-Muslim and he is living among Muslims with the so-called Aqd al-Zimma, that he got now equivalent to Aqd al-Zimma is to have someone who's non-Muslim to live among Muslims because he legally get in there, like he has a visa or he has, he stays amongst Muslims and they accepted him, then he has all the rights of Muslim regarding not selling against himself. Okay, before we have Muslims, we have Ahl al-Zimma, we have Darul Harb. Darul Harb means those are the nations who are in continuous fight against Muslims. Which means that if you are out of Darul Islam and in Darul Harb, you might easily be enslaved or killed. And this situation is not, I cannot think about any part of the world where maybe very few parts. Okay? So the concept of Dar al-Harb now is not like Dar al-Harb used by the early scholars. Because before, if you go outside the territory of Muslims, the borders of Islamic world at that time, you would be in danger. You could either enslaved or killed. And this is not the situation now. You go to a country, with a visa, your rights will be respected, protected. So the concept of Dar al-Harb. So the concept of Zimma, that any non-Muslim lives among Muslims who come with through a right way, with a visa, for example, and fulfill all the conditions for his presence over there, then his rights must be treated. So he would be, the same thing is applied. Okay, now.
So I just want to understand, you said because the situation of Darul Harb, so how would you define Darul Harb nowadays?
Sure, Darul Harb is defined as a land that is engaged in battle or war against Muslims. Okay? They waging the war against Muslims. That, the intention, like the Crusaders when they invaded the Muslim world. Okay? That time, if you go outside the borders of Muslim land at that time, you would be enslaved or killed. Right. Is this the situation now? Even non-Muslim countries, if you go to the embassy and you get the visa and you flew to that country, they're not going to kill you or enslave you. Okay, so we have to be careful, about application of those. When you go this terminology, when you read this terminology in the books of fiqh, okay, we have to know the meaning of this terminology.
So in other words, loosely we can say with confidence, Darul Harb does not exist anymore.
No, I'm not saying that, but most of the countries, they won't enslave you or kill you if you get to their lands, even if you get illegally, right? Even someone cross the border illegally, they won't kill you. But this is not the case like before. If you get into the land controlled by the Romans, they will do that.
Sheikh, does that apply to places that you cannot practice your religion? Because there may be some countries that you cannot practice your religion.
So you should not go.
So that should be, maybe it's not Dar al-Harb, but you cannot practice your religion. It's as close as it can get.
Sure. You cannot stay in any place where you are unable to practice religion. Even if you are, I'll give you an example. Even if you are Sudanese or Egyptian, you are unable to practice your deen as required in Egypt, then Egypt is not your place. You have to find, and Allah says, قَالَ وَأَرْضُ اللَّهِ وَاسِعَةٌ. The whole universe belongs to Allah subhanahu wa ta'ala.
And there is a lot of examples of Muslim countries where people want
Exactly. Especially before the Rabi'ul Arabi, in Tunisia, it's very hard to practice. In some places, it's very hard to practice, your deen. You can practice your deen freely here or in France or Europe more than in your... But, there are other factors. Yes, you can practice your deen freely here, but also the pressure on our children, like in public schools. You have to, you have to look to the whole picture. But in general, if you can practice your deen in a place better than your own hometown, then that should be your watan.
So I have a question. It was about the previous one. So the question came up that this person has a property, and a church is coming to try to lease the property from this person, right? So the question is, what is this unacceptable?
This will be a training for you. We set the principle. وَتَعَاوَنُوا عَلَى الْبِرِّ وَالتَّقْوَى وَلَا تَعَاوَنُوا عَلَى الْإِثْمِ وَالْعُدْوَانِ. Or this property will be purchased by someone who's going to turn it to a nightclub or a liquor store or a bank or anything of that nature. So he applies the same rule. But if I sell it to someone and I don't know what's going to do it, and then he turned it into a liquor store, well, this is, of course, I did my part, and I get into a good transaction. But here, if you are sure you are going to sell it to someone who's going to make it on a church, for example, or if he make it a church, are you promoting good or evil? So the answer will determine whether you can sell it or not. Now, now this part of riba is very important, and I see people maybe they get bored now, and we can do riba inshallah tomorrow, inshallah. This is unit number 3, right? We have 3 more units.
How much of the unit that is coming?
This slide is number. Yeah.
I just want to make sure we're not rushing.
This number 32.
Yeah, this is 30. Oh no, we're just halfway through. So 32. Yeah, 57.
Yeah, about 20 more, 25 more slides.
3 more units after this.
No, but I mean the riba section.
Yeah, that's the main thing.
Right.
So this means we have to do.
No, what I'm saying is, after this tomorrow, we still have 3 more sections.
This riba section is very
Yeah, the most important sections, after riba, we're going to talk about modern transactions. It's very important. Then we're going to talk about partnership. Because many people, they have a lot of confusion and problems, You hear this a lot, we get into partnership, and then they get in dispute and they don't know. A brother called me a couple of days ago. they get into a transaction. They don't know what that transaction is. It is like financial partnership or it's mudaraba, okay? And they get into debts and they want now to file for bankruptcy, for example. And they don't know what to do, how to share it, you know. We need to know about partnership. It's very important. Many people, they do businesses, okay? The contract of authentication, like for example, mortgage and financial guarantee, it might not be as important as, you know, talking. So we can, if you don't have time, you can just drop the last part, which is ممكن يعني والله افتكر after ظهر is good. 1:30. And if we need it to, we can, inshallah, we can have a session maybe.
If you want to pay the odds and then just do a little bit and then tomorrow come back and complete. I have time. I just want to make sure. No problem. Is everybody okay with that? I think we can extend it.
You want us to stop now?
انت تكلمت عنه الحين
سبحان الله.
وعندي حاجه ضروري جدا.
طيب خلاص يعني معنا خلاص ان شاء الله ما مشكله. No problem ان شاء الله. فانا بقول لك يعني it's all the time there are يعني as a matter of importance, you know, riba, modern transaction, because we're going to talk about credit cards, insurance, okay, and mortgage, you know, of course, conventional banking system, okay, and then after that, partnership. And then the last part, which is about how to authenticate a contract to assure the creditor that, you know, his money will be paid. And this includes mortgage. Mortgage means rahan, yeah, to have hold a property or an object to guarantee the payment of the debt. It might not be relevant, you know, or not relevant, but important like partnership and other. So inshallah, we'll see. I don't think all of them, because one of the brothers, he says he has very important, you know. No.
Tomorrow, we might have to start early, or we might have to come late. We can finish for another day, right? You know, I don't know. We can speak through certain sections.
Okay, yeah. Inshallah, I tried. If you notice that I skipped many of those transactions, which is not relevant or it's not as important as, you know, others. So inshallah, we'll try, inshallah, to figure something, inshallah, tomorrow.
We'll fix the presentation so it doesn't take so long.
Khalas.
Yeah, we'll take the animation out.
Khalas, yes. And if you can get a copy of the presentation and hand out, that will be very good. Yeah, inshallah. طيب سبحانك اللهم وبحمدك أشهد أن لا إله إلا أنت أستغفرك وأتوب إليك وصلى اللهم وسلم وبارك على محمد.
الله أكبر الله أكبر الله أكبر أشهد أن لا إله إلا الله أشهد أن لا إله